And welcome everyone. In today's webinar, we'll find out more about the legal challenges in international supply chain and how to overcome them. We've got a very exciting panel of speakers, and we're very pleased to see you here. Before I hand over to our presenters, I just wanted to remind everyone that the session will be recorded and shared online later today. The webinar will include an approximately 45-minute presentation, followed by a Q&A at the end. You will be able to switch on your mics and cameras for the Q&A panel and ask your questions directly to our presenters, or alternatively, you can use the Q&A panel in the Teams app to raise any questions. Now, I would like to also thank Hexagon, who are sponsoring today's webinar. They're a global leader in digital reality solutions and that make manufacturing smarter. To find out more about what they do and all of the exciting projects they work on, please visit their website, hexagonmi.com. Now, without further ado, I will hand over to Dominic, our presenter, who will lead today's presentation. Over to you, Dominic.
Thank you, Lena. A very good morning to you, to all of the delegates today, and welcome to this webinar, charting a course through legal issues in international supply chains. A big thank you to STC and also to Hexagon for hosting and sponsoring of today. The webinar has been provided today by HCR Hewitsons. We're a top 60 law firm with a long heritage of providing services to businesses in the region. We act for local, regional, national and international businesses. Our Central England office in Northampton is one of 10 offices reaching across the UK from London and Cambridge to Cardiff in the west. In Northampton, we have a team of over 100 people covering a range of specialist business services and draw on the resources of over 750 other people from elsewhere in the firm. So I and my colleagues today are members of the firm's international technology, commercial and dispute resolution practices, and we're going to try and make this webinar as practical and useful as possible. The backdrop to today, of course, has been perhaps the most disrupted period for supply chains since the Second World War. I mean, the list, and we can look at it, they're all familiar to us all. A fundamentally changed political and economic relationship with our closest market, belligerent political environment across the pond, signifying a partial withdrawal from the international rules-based order, sea changes in demographics, economies, and political landscapes in the Far East, shortages of essential raw materials, batteries for new technologies, a desert of semiconductor supplies worldwide, presently being lifted, thankfully, the small matter of a global pandemic, a grieving war in Eastern Europe, disrupting energy supply markets, and unprecedented fluctuations in container prices. We could go on. What is the overall theme, however, and that is the impact demonstrates the interdependency and interconnectedness of our markets. And that is the setting for some of the legal challenges we're about to discuss. We only have an hour or so, so there's challenges for time. But as Alina suggested, that if you've got any questions, we can pick those up later in the sort of panel session, or even after today. Please do feel free to contact us, and we'll be very happy to help. Our contact information is online. So some further preliminaries in terms of introduction, so you know who each of us are. And my practice is dispute resolution, problem solving. This ranges for work in the management of a dispute to arbitration or litigation if necessary. And commonly, I might be assisting a manufacturer or purchaser or designer of an engineered component, commonly involving some sort of technology that operates in the setting of a computer system. The destination of the component could range from consumer retail to IT infrastructure to a defense system or energy supply. The component or an ingredient of it will travel cross-border in the supply chain, sometimes many times. So that's broadly the field where I operate. That's me. I'm going to introduce you now to my other colleagues here today, Nicholas Groffman from the international team and David Bainham from our commercial team. Nicholas, over to you.
Thank you, Dominic. And thank you for that unexpected and brilliant summary of the geopolitical situation. I thought that was an added bonus there on top of being a lawyer. Now, I wonder if we could go through to my slide, Galina, if you have control of that, the first one. That's it. Thank you. So in this talk, I'm going to be just giving an overview of issues in the international trade arena. This is just issue spotting. Obviously, this isn't going to be a guide to actually how you do international trade, but I hope some of these issues will be things that some of us may not have necessarily thought about in great deal. The first one is probably relatively more commonly addressed. Certainly, this is in order of when I was last asked the question by a client. Rules of origin, as I think many of us know, rules of origin help you work out where your goods originate and whether they're covered by trade agreements, and if there are tariffs attached to those goods, and if so, what are they, depending on which country they come from. And that can vary quite a lot. The largest volume of questions we had on this was immediately after the signing of the TCA with Europe, because many people who had been exporting or thought they had in fact been simply sending goods into the EU, which never really counts as an export from a legal point of view. Suddenly they were exporters. People who were familiar with exporting outside the EU were not so shocked by the idea of having to worry about customs tariffs and AORI codes and rules of origin. So with rules of origin, there's all I'll say on this is that sometimes depending on how you package your goods or cluster them together, you can actually get a different HTS code and therefore a different rating for customs purposes. So for example, first aid kits have a different rating to the individual components of a first aid kit. So sometimes there's room for cunning arrangements in the way that you do this. Similarly, we get questions because of sanctions. So the sanctions that have been put on Russia, not just according to individuals and companies within Russia, but also according to types of product. And again, it may be that you can send a product overseas to a country that's under sanctions if it is under a specific code and not if it's under the other code. Now, a more general topic is the outsourcing to third parties. Why we do this rather than trying to distribute or source materials ourselves is because in the case of distribution in another country, you can rely on a third party there, an in-country party, to get the right permits, for example, to understand local law, and more importantly, to protect you from risk within that country to a certain extent. Relying on the knowledge of the market for distributors comes with certain risks, however, and you can't be completely shielded from certain types of challenge within that country, which we'll look at in a minute. Similarly, with suppliers, the suppliers are going to know have access to cost-effective goods and materials that they're going to send to you. But outsourcing comes with the need for contracts, in our view. Now, many people do this based on purchase orders if they're dealing with suppliers, or other very informal arrangements, such as a simple power of attorney. And we think that actually carries greater risk. And statistically, it shows that it does. We deal with more disputes coming from cases where people don't have a clear contract in place. And moving on to the different types of IP protection, issues that you need to be aware of. Now, David's the expert on IP here. I just wanted to mention from an international point of view that you cannot simply assume that other countries will follow the way that the UK does things. And most notably in certain civil law countries, you'll find that there is a first to file opportunity for people that doesn't require any sort of bona fide proof or the fact that there's already using the mark. And it makes it very difficult for you to challenge that if someone actually has deliberately taken your mark and registered it, because you won't simply be able to say, well, we're the real company with that name. They should hand it over to us. You'll end up in a difficult situation that sometimes involves negotiation if that happens. You should be aware of domain names and register them at the same time as trademarks. And that's because otherwise there may well be someone who spots a trademark's been registered in a particular country and deliberately registers the domain name. So try and do them at the same time. Now, one other point here is that we can, firms like ours can obviously handle your IP portfolio around the world. We do that through a network, but also we do name creation in certain countries. So where the English name might not work, we have been involved in helping people create names. So if, and actually in some cases you should probably file a trademark even if you don't intend to engage with that country. So China being a big example, preventative registration of marks, it can be very useful, because it stops somebody passing off as you, even if you don't intend to use that market. They might then distribute under your name outside China. Could we go on to the next slide now, please? Okay, thank you. So international risk management for contracts, what I'm talking about here is your exposure is something that you can't really control once it's outside the shores of the UK. And in some cases, your contract won't even protect you from, for example, from claims from people who can see your brand. You may contractually say that they should sue the distributor, but they may have a right, a regulatory or tortious claim against you. Now, how do we manage that risk? Well, the biggest aspect of risk management is actually not in cunning contract drafting, it is in due diligence. And that's a proper investigation of the counterparty that you deal with overseas, whether it's a distributor or a supplier or someone else. We think that money spent on investigation of that counterparty is more important than the money that you spend on the contract drafting. And again, this has to be done through trusted networks of investigators, as well as desktop due diligence that we can easily do from here, what is called signals intelligence in the intelligence business, and human intelligence with the using on-the-ground agents. And we would run all that, not just from a legal point of view. And so whoever, it doesn't matter who you're engaging to do it for you, but we think that's a very important part of risk management. And moving on to methods of payment, the reason I've highlighted this as a key issue is that a lot of people, obviously, if you can get paid up front, brilliant. Get everything paid up front before you ship anything. However, that doesn't always work like that. And similarly with supply, if you can receive the goods first and then pay, you've won. But very few people will agree to terms like that. A common compromise, actually, it used to be the default suggestion by UK Export Finance and the DIT. If there's anyone here from those institutions, I think that they may have changed the practice now, because it's been pointed out by us, among others, that's actually letter of credit can be a very risky way of doing business. So the great thing about letter of credit is it seems to be completely independent of the parties, and as long as certain objective criteria have been met, the funds under the letter of credit are released. However, the risk in that is that the threshold for proving criminal liability for letter of credit fraud is very low in lots of countries, not so much in the UK, but in many civil law jurisdictions, including Turkey and China and others. If you draw under a letter of credit, but the counterparty that's having its funds removed from the bank thinks that the contract hasn't been performed, then that can become immediately a criminal investigation. So very important to be careful about how you do that. And moving on to my last point here, and actually we're still talking about criminal risk here. That often gets missed out. We always think the most important thing to look at before you even worry about getting paid or indemnities or warranties or the usual nuts and bolts of a contract is just to make sure that your criminal risk is reduced to the lowest possible level, because that's the most significant risk of all. That's the one that affects your personal security, safety, and freedom. And the most commonly arising are sanctions risk. Those typically are UK or US sanctions that affect us. And so sanctions on Russia, or Iran, and others need to be examined if you're dealing with any of those countries, and some other unexpected individuals around the world who may not be from sanctioned countries. So that needs to be checked off. State secrets, again, we never think about state secrets in the UK because our attitude to secrecy is incredibly lax compared to a lot of other countries. Or you could say that we allow freedom of information to circulate freely. That's not true in lots of other countries. So you need to be careful about the information that's included and dealt with but in your business dealings. And foreign exchange, again, that's a very non-UK sort of risk area. And that's typically countries such as India, China, Tunisia, and so on, where currency is trapped within the country and can only be sent out and converted into hard currency by quite sometimes quite onerous or restricted practices. You need to be careful that you're not falling foul of those issues. And I think that's probably enough. I've tried to be brief here. Would welcome any questions later. Thank you very much.
David.
Thanks, Dominic, and thanks, Nicholas. Morning, everyone. My name is David Bynan. Just very briefly to give a bit of an overview about me and what I do in my practice. I'm predominantly a commercial technology and IP lawyer. What that means is that I have a fairly broad commercial contracting practice. Naturally, there are various different elements of that impact supply chains. So things that I typically get involved in are anything from sort of agency distribution type arrangements, manufacturing, outsourcing arrangements, but equally from an IP perspective, more developed digital or online solutions as well. Invariably, a lot of that work that I do has a cross-border element. More often than not these days, most things we get involved with have an international element, at least to some degree or another, and that's certainly true, obviously, in the technology, software, digital environments as well. A lot of what I do then crosses over with the work that Nicholas does, and Nicholas and I have reason to, discuss those matters on a regular basis. For the purposes of this discussion today, my value is around the IP aspects of those international transactions, and things that we need to be aware of from an IP perspective, whether we're talking about more traditional commercial arrangements like agency or distribution, or alternatively, potentially more sophisticated digital solutions like outsourcing or SaaS solutions or cloud-based services and that sort of thing. So what I wanted to do very briefly, in a similar sort of tone to how Nicholas has approached the international aspects, is just give a bit of a whistle-stop tour of those issues, just to sort of signpost them, so that hopefully we can stimulate some interest and discussion later around these issues that you might be coming across in your businesses. So the first thing just to pick up on there is the different categories of IP rights that you may have in your business, or probably will have to some degree or another in your businesses. So just very briefly, we're probably all familiar with patents. And when we talk about patents, we're typically talking about a monopoly right that's a registrable right, providing us with protections in respect of our inventions. Typically, it's quite a difficult thing to get a patent. The state legislation, whether it be in the UK or more internationally, is quite protective of awarding patents because it's such a powerful right to have. There are some statutory tests around it. Broadly speaking, your invention needs to be new. It needs to involve a substantial inventive step, but also the invention needs to have some sort of industrial application in the real world. So depending on where you are in your development as businesses, depending on what you might be doing, you may well have some patentable inventions. Equally, in a sort of manufacturing, outsourcing, supply chain situation, you may be having access to patented technology, whereby you might be utilizing the technology of a third party, whether it be under license or what have you. So that's the first one, and obviously a fairly important one in the world of manufacturing in particular. Moving on, Nicholas has already mentioned about registrable marks and branding. So here we're typically talking about trademarks, obviously, and invariably, trademarks, we're talking typically about signs or symbols that are associated with your products or services. They can take many different nuances, as we know, and it's also capable of registering, logos in their entirety without words, but equally registering names and graphical depictions of names and that sort of thing. Invariably, some basic tests around that are that, provided we can graphically represent the trademark that we're looking to register, then that's acceptable. But equally, there are some rules around distinctiveness as well. So it's one of the key requirements for registering trademarks is to make sure that our brand that we're getting a trademark for isn't confused or potentially capable of being confused with other marks. Just moving on very briefly to touch on design rights. These can potentially be quite useful rights for us to have in our businesses, and I think that's more so in probably the last decades or so, because what we're seeing more of, certainly insofar as clients that we act for, is that, as I mentioned earlier, it can be quite difficult to get patent protection in respect to of many things. The tests can be quite onerous. The technologies can be quite complicated. Quite often the technologies involve what we call a co-location with other products, which sometimes make it difficult to get a patent as a result. So design rights can be a way of potentially getting a registrable protection for your products, notwithstanding the fact that you may not be able to get patent protection. And quite frequently do these talks and presentations, and one of the best examples I think I come across for design rights are the Dyson range of products. Dyson naturally will have patented parts to their products, whether they be their vacuum cleaners, their hair dryers, or their toothbrushes, but also a big right that the Dyson company relies on insofar as protecting its products is the design right element. And we'll all be familiar with Dyson's products. We all know what they look like. We all know the color palettes they typically use, whether it's the sort of standard gray elements or the highlighted purple or yellows, and those sorts of things, and how the product is configured, the shape and feel and look of it, the patterns, the textures, etc. They're all potentially capable of being protected by design right. So as I say, it's quite a useful right to be aware of, because it does give you additional avenues to protect your products and services, or your products, in the event that patents aren't available to you. And then the very last sort of core IP right I want to talk about, just so that we're all aware of it, is copyright. And it's probably the easiest one for us all to be aware of and to utilize on a daily basis, because copyright, unlike the others, arises automatically. So it arises automatically in our artistic and literary works at the point that we create those works. So if we're simply sitting in our offices, developing a strategy around a new product or a new service, or potentially drawing up some schematics for a new product or some new designs, at the point of creation, we are developing copyright in that document. And there's no need to register it in order for us to gain protection from it. What's quite important to pick up on this point is an awareness that copyright helps us protect the expression of an idea and not necessarily the idea itself. So if, for example, we were to utilize copyright to protect our design in a product, then the document that we've recorded that in will be subject to copyright, but the ultimate product wouldn't necessarily be protected by it. And that's, of course, where you need to supplement your strategy around IP creation with things like patent protection and design rights and that sort of thing. So that's sort of just a bit of a whistle-stop tour, just to give you a flavour of the sorts of things you're dealing with. And as I say, in the context of this discussion, these rights will invariably exist to some degree or another in your own businesses, but also broader than that will exist in the businesses that you're engaging with in terms of your own supply chains, whether they be domestic or international. Could I just move on to the next slide, please, Dominic? So in just moving on from there, then, in terms of those engagements you have with third parties, there are some common pitfalls that we see in practice around IP creation, and also in terms of those collaborations with third parties. Invariably, more often than not, especially when we gain new clients and start working with them around their IP portfolios and the commercialization of that IP, invariably we come across ownership problems around the IP. And that's usually arisen because we're being engaged at the point when maybe things have been happening in the business for some time, maybe the business has gained some traction and has developed some early success, and a lot of excitement and initiative has happened around that, and then some engagement with the lawyers around the IP has happened at a later date. And the sorts of things we see there are where IP rights are being created in businesses, but not necessarily in a manner that vests the ownership of the IP in the business. And that might be because there's an individual who's developing key IP of strategic importance who's not formally engaged by the business. They may not be an employee, for example, or it might be that they're a consultant who's been brought in on a maybe temporary part-time basis to provide some specific skills and expertise. And maybe not under a formal consultancy arrangement, or maybe there is a formal consultancy arrangement and maybe it doesn't deal with IP. And I think one of the things we see around that specifically with consultants is that invariably in that sort of role where someone is being brought in with some specific industry expertise, invariably they're probably doing that for more than one business, because the nature of how they go about their day-to-day operations requires them to do so. And that can sometimes cause us a problem, obviously, in terms of IP creation, because you can find potentially that more than one business thinks it has a stake to some IP that might have been created by that individual or by that individual's company. So that's something to be aware of. And I think, the sensible guidance around that is that if we think we're doing anything meaningful with individuals of that nature, is to at least stop and take a breath at the outset and think about how we need to deal with it from an ownership, transfer of ownership and creation perspective. And in a similar context, the same is true for collaborations with third parties. Clearly in our businesses, very few organizations get to do everything themselves. Certainly, at the sort of smaller end of owner managed businesses and growing businesses, etc. And clearly there's quite often a commercial advantage to entering into collaborations with third parties, whether that be by way of contractual collaboration or potentially by entering into corporate joint ventures, etc. And in a similar context to the ownership point around employees and consultants, it's important that we make sure that those sorts of relationships with third parties are actually dealt with contractually properly. And we're probably familiar from our dealings with day-to-day contracts, etc., to think about terms like foreground IP and background IP, and these key terms that typically find their ways into contracts of that nature are obviously in there to try and identify that both parties, or potentially more than two parties, could be coming to the table with their own background IP, their own things that they've developed independently of the collaboration, but then the terms of the contract need to clearly identify what happened to the new intellectual property that's been developed as a course of the collaboration. And clearly there's potentially a few options on how that's dealt with, but it's really important to deal with that at the right stage. And again, as with the employment and consultant type aspects that we come across, quite often we see this being dealt with maybe 12, 18 months down the line, and it can be quite difficult to unpick what's happened, because at that stage maybe the collaboration has been a great commercial success and there's an awful lot of IP and the horse is very much bolted, and we're trying to sort of work out what's happened and how it's got there. So I think the key message on both of those points is to stop at the very early stage, at least stop and think about it, try and think about what the commercial intentions are and how we overcome any challenges that might exist in that respect. And then the second and last point for me on this aspect is around the importance of confidentiality, and confidentiality specifically in the context of know-how and trade secrets. And what I'm keen to stress on this particular point is invariably we take a lot of calls from clients, new instructions from clients, and invariably they might often be saying to us, oh, we want to talk to you about our IP, and we have some new IP that we've developed, and it's really important that we do something with the IP. And what happens more often than not is when we actually scratch the surface of what is happening or what has happened maybe internally or with a third party, what we're actually dealing with is not IP in its core sense, but more likely confidential information, whether that be know-how or a trade secret. So what I mean by that is that the IP is not within one of those heads that I identified on the previous slide. It's not an invention, it's not patentable, it's not a trademark, it's not potentially a design right, it's not potentially subject to copyright. It's more a case that it's actually a really clever way of doing something that someone somewhere has developed. And when it comes to that, we can't overly stress the importance of maintaining the secrecy and confidentiality of that information, whether that's simply under an NDA, which just deals with the discussions between the parties and the work that's going on, or whether it's under some more sophisticated, more developed provisions in a broader commercial agreement in our supply chains. But I think it's an important point to note, because quite often, even if we do have one of these core IP assets that's of any value to us, that IP asset will be supplemented by important information around the fringes, which actually is as important as the intellectual property asset, but is nevertheless not protected under the scope of what is traditionally regarded as IP. So I think it's important just to flag that, because it's something that we come across most days in terms of our IP practice and our advice. And that's probably it from me initially, Dominic, I think.
That's great. Thank you very much, David and Nicholas. As you will have gathered from Nicholas, speaking about rules of origin, speaking about IP, David also following through on that absolutely key area associated with supply chains. What I'm going to try and do over the next few minutes is just draw some perspectives from the experience of things, that we have had in helping clients sort out problems, and that it's about taking experience of worst case scenarios and bringing it to the forefront to give us some best case thinking. So really this is about perspectives. A first perspective really, which I think is an important one, which is that a supply chain is not a simple y-axis upstream, downstream situation. Commonly when you're engaged with your customer or your suppliers, you might be talking in a bipartite environment, two parties. You might even have three parties associated with the arrangements that you're agreeing. But we know that in the current supply chain context in global trade, the mix of interconnectedness and interdependencies requires that we think 360 degrees. X and Y axis, but 360 degrees. We've got to look at the outset of making business at the whole context to be able to understand how we might plan things through to address the legal issues. Now, dispute resolution lawyers like myself are slightly different from our really positive commercial business making colleagues such as Nicholas and David. Bad news bears we've been described as. I like to think of it in a slightly different way. And this is really when we're making and building business through the relationship, the forming of the relationships from a legal perspective. And that is, you've got to think of this as somebody who actually does like running to the back page of the novel to see how the story is going to end. Commonly, you will find in complex legal agreements that there are a number of provisions that are relegated to the back page, to the back few pages, which are ostensibly presented as being, well, perhaps the things not to think about because they're not that important. And what I'd like to do really today is just emphasize the value there is in thinking ahead about worst case, potential worst case, or maybe not worst case, but some of the issues, the problems that can arise. And when we do that, when we look at the sorts of challenges that arise from time to time, they might come in two areas. They might come in a commercial environment, a commercial disagreement, or a liability disagreement where something has gone wrong. They are two different types of dispute. A dispute over what should be paid for goods and services within a supply chain is got to be looked at differently than a dispute that arises where something may go wrong. A product defect might arise. So I'm really keen to advocate, invest thinking at the outset of relationships in how you might deal with not just the pricing side of things, the cost side of things. A lot can be done on price and cost ratcheting, but also to look at how you might nip things in the bud if problems come up in the supply chain as far as defects or those sorts of issues. Now, they're quite important because we live in a world of just-in-time supply, and we may not have the privilege of a lot of time to resolve issues. So one of the key things to do is to think around how you might capture issues that might go wrong at a really early stage. And that's really about managing our issues, and that's about putting out fires before they have set light to the chain. Some work has been done on the development of what are called disputes boards, and the theory behind that is very much that idea of nipping things in the bud, a referral of dispute risks for early management. They have largely found themselves their way into large-scale infrastructure projects, often where the public sector, public funds are involved. And they're not going to be suitable necessarily for most supply chains, which need nimble and complex arrangements. However, what they do point to is the importance of having some sort of mechanism in place where you can just nip those things in the bud, have the conversations that need to be had with the right people, and to build those into the relationship, the legal relationship that you have through the terms of your agreements. In an international context, when you're not simply talking about a domestic setting, it becomes increasingly important because there is a time cost formula associated with crossing a border. So think practical and think cultural, because different countries, jurisdictions see the resolution of problems in different ways. So having a good understanding, that due diligence that Nicholas was talking about earlier at the outset, is going to be really important for sorting out problems before they set light to the chain. And think collateral as well, the law of unintended consequences in the chain. Now, how do you do that? Well, I highly recommend the idea of scenario testing. So identifying the parties who are connected within your chain, on whom there are dependencies, and to work out actually by simple testing, scenario testing, how a problem might come up and how it might be efficiently resolved to ensure that there is the minimum of disruption. Now, if things do go wrong, you might need to have resort to a legal system. And there is one thing that it is important to discuss with your lawyers in that case, and we will be discussing with you, is what choice there might be of law to apply in a cross-border context. Most jurisdictions around the world accept the party's choice, express choice of which law to apply. What law is appropriate for a particular chain or a particular part of a chain is going to depend upon what fits and what suits and what type of context the chain exists. Commonly, when you're looking for a law, you're looking for something that builds for a wide acceptance. You're looking for one that has, it's designed for working in a mercantile setting and also has predictable outcomes. Now, we are inevitably going to be advocates of the choice of English law for those reasons. However, it may not be the case that English law is the best law for a particular issue. So it is the case you can also choose an express choice of law for different particular issues that arise in your agreements. So the idea really should be about, in my view, building confidence through the choice of law. And that will require a discussion with your legal representatives, and we can help work through with you which would be the appropriate law for a particular case. One always has to remember that even though you might choose a law for a contract that has a relevance to a particular jurisdiction, it might need to be enforced. A term might need to be enforced in a jurisdiction. If you had for example, a judgment or an arbitral award from an arbitration panel, then you might need to enforce it in a jurisdiction. But there can be laws, mandatory laws of the jurisdiction, which actually make it difficult to actually enforce. So having a view of where you might need to enforce your obligations if things go wrong is quite important. And then I'm just going to turn very briefly to the value and challenges of arbitration in the supply chain. It is going to be very commonly that in an international context, a recommendation will be made to choose arbitration. And the reason for that is because judgments of different jurisdictions are not necessarily going to be accepted for enforcement in a foreign jurisdiction. Arbitral awards, however, have a much wider acceptance across the globe through, for example, those who have joined as signatories the New York Convention. there are many jurisdictions who have signatory to the New York Convention to recognise arbitration awards. That's basically decisions of an arbitration panel akin to a court judgment, and enable them to be enforced in the jurisdiction. However, there are still over 50 jurisdictions that are not signatories to the New York Convention. So the fact that you might have agreed arbitration as being a way of resolving a dispute or deciding a dispute, then that is not necessarily the most straightforward answer. It is important to think ahead for where you might need to enforce your terms. And the other really significant aspect, this is another perspective. I've talked about the 360 degrees perspective, that idea of the X and the Y axis. I've talked about thinking about different types of disputes, commercial liability. When it comes to arbitration, it's important to have a perspective that it's a creature of agreement. That means that if you are a party to an agreement that a dispute be referred to arbitration, then that is the route which the case will go to. But if you have a party in the supply chain who is not a signatory to your agreement, you cannot rely upon that way of resolving the problem, that way of managing the dispute and determining the dispute as being either capable of being enforced against a non-party, or to be able to force that party to join in the arbitration, in the dispute. And I have very specific experience of this, where we were able to assist a client who was trying to be leveraged into an arbitration. They weren't signatories to the contract, but they were a relevant party in the supply chain. They were part of the component supplying matrix, and yet it wasn't those who were trying to join my clients to the arbitration were not able to do so because my clients were not party to the arbitration agreement. So there can be major issues in joining relevant parties or enforcing against non-parties, and that is part of that risk thinking that we recommend takes place before you enter into significant contracts. Of course, the amount you invest in that worst case thinking, that forward thinking, is going to very much depend upon the significance of the contract, the agreement, the value proposition, and your own sort of value that you attach to the agreement. But if, for example, your business is heavily dependent upon a particular contract, a particular relationship, supply relationship with a partner, and increasingly, of course, in the field of technology, collaboration is at the heart of it. It is really worthwhile investing in worst case thinking, because that can be your best case thinking. I think that probably ties up our main presentation today, and I think we can now pass on to the section where we can perhaps take some questions from people. Lena, I don't know whether you want to manage that process.
Yes, of course. Thank you very much, Dominic. It's been a very thorough and insightful presentation. We have a few questions that were submitted prior to today's event, and I just want to encourage all of our guests to also use the Q&A section or the chat function to raise any questions. So the first question we've got is for Nicholas. How do you help clients carry out the due diligence on their suppliers or distributors?
Right. So there's a lot we can do with our own proprietary software. And to be clear, what we're talking about here is due diligence investigation, not the kind of due diligence that people do for mergers and acquisitions, which is obviously much more expensive. And whereas what we are doing is just trying to make sure that the partner you're about to sign a contract with is all that they say they are, that there isn't necessarily a PR risk attached to dealing with them, that there isn't some sort of potential corruption risk if you're dealing with a distributor. And all these things are very important to get right. So what we would dig into is the company itself, but also the people behind it. Because your risk centers are individuals. A company isn't actually a thing that can act in a certain way. So it's the people behind it are important. And we do that with, as I mentioned before, desk-based research, but also agents on the ground. In one case, we actually had somebody flying a drone over a building site to make sure that the place in question, there was a suspicion about what it was, and we were able to fly it down to view the construction site, and it turned out it wasn't what was being told to the client. And in that case, it doesn't mean that you therefore mustn't sign a contract. It simply means that there are certain risk issues that need to be fenced off, and that can be done by an open discussion with the counterparty, or by adjustments to the contract itself.
That's great. Thank you very much. Just a reminder to everyone as well that you can now unmute and switch on your camera. So if you wanted to ask your questions in person, you can do so. In the meantime, we do have another question for Dominic. It's what law is the best law?
Well, as I think I mentioned, English law is a really good law, but it isn't necessarily the best law. Is the one that definitely fits, it is fair to say that if, for example, you are looking to rely heavily upon a party that is based in, let's say, for example, in Japan, then it's definitely worthwhile working through whether or not your parties in Japan, your commercial partners, actually have an understanding of what the legal what the English law might be, and whether or not you have an understanding of what Japanese law might be. It is in most sectors, English law has been accepted as the favoured law for precisely the reasons I've explained, but it's not necessarily the case. If you are not, for example, if there is no reciprocal enforcement convention or reciprocal recognition of laws convention with a relevant jurisdiction, then you might well want to think about the local law in one of the developed countries, for example, where you will have where you might need to enforce locally, and the local jurisdiction will be the most familiar. But I would still say, in most cases, we would be looking to start with at English law. This morning I had a bit of a wander through some issues associated with a New York case, and I have to say I found New York law, the approach to New York law, being highly complex and quite difficult to follow. So for clarity, for reliability, for wide acceptance, I would generally favour English law, but it's not necessarily the case.
Thank you, Dominic. We've got Sean wanting to ask a question. So Sean, over to you.
Yeah, hi there. Thanks for your presentations. I think this meeting, this video call, it's been long overdue. And so my name's Sean. I work for a company. I'm a venture capital scout, and I work in the venture capital space. For me, getting patent and IP in the UK is an absolute mess compared to the US. And one of my biggest problems is getting an IP valuation. It feels here in the UK that, particularly around Innovate UK, they're not engaged with the startups. So my question to the panel is, where can I go? And I'll keep it down to one problem. Where can I go to get an IP valuation? Because if I send the startup to Cardiff, the IPO office, they provide a template, but they don't provide any more kind of advice beyond that. And yes, that's kind of my question, because a lot of the IP lawyers that I speak to, they don't view kind of like the tech startups as kind of good business. You know, it's like small beer. So my question to you is, how can I get that resolved around not just filing the IP, we know what it is, but getting the IP valuation to, for example, the econometric kind of method?
David?
Yeah, well, that's probably for me. I'm not sure how helpful I can be if I'm perfectly honest. It's a very technical IP question. Presumably, are you utilising patent attorneys for the work you've done?
In my organisation, I have 7 employees. Over half of those are IP lawyers for very good reason. 75% of the successful pitches, okay, they get rejected in compliance. One in 3 because of poor IP. Like they don't have a strong IP. So and I'm not pointing the finger at any one person. I think it's a systemic problem here in the UK where the government doesn't really kind of support it. And also, it's kind of the startup, the founders left in a chicken and egg situation. And my VCs, they're actually petrified of, get infringement more than actually making lots of money. And so, what from my experience, what happens is that the IP law, they say, oh well, this is a cost-benefit analysis. You need to go to a professional service provider, and then that professional service provider says, oh no, this is IP. You need to get like an IP lawyer. So so in my portfolio, I have some. They're kind of running around, and it's just, it's just an annoyance, and I'm just trying to get in the US, for example. This is an actual use case, right? I went with a startup to Walmart, right? That founder went to the bookkeeper in the Walmart, and then from the bookkeeper in the Walmart recommended him or her to an IP lawyer. Like it's with their groceries, it's that straightforward. But in the UK, it's defunct. It's really, and I'm trying to get to the bottom of it as to how can I get this IP valuation? Because obviously a strong IP valuation means that the founder can go and get the raise that they need.
Absolutely. So are you invariably talking about situations where someone or an organization is pre-patent and they've identified a patentable technology? Are they in application stage, or has the patent actually got to grant?
It's more even just so, for example, when my team goes in, we identify that they have a strong innovation, and we find out that they don't have an IP registration number. No geographic kind of registration. Particularly now with blockchain and Web3, there are a lot of supply chain apps now. If you look on Innovate UK, one in every 2, 1 in every 3 Web3 is a supply chain app is using blockchain kind of technology. So it's just really trying to define what the IP strategy is, and then going through the steps. Okay, but when you explain it to the founder, as a consultant, right? I would disagree that I have to do a lot of education around why they need it, and then they see the fact why they need it, and then there's a big price tag to it, 5,000, 6,000 kind of pounds. They just don't do it. In the US, it's a lot more straightforward. They understand it, they get it, they just do it, they file it. Okay. They even have IP patent kind of parties to do it. But here in the it's and I don't know how to best go about it apart from having people kind of in-house to kind of deal with it. So it's just really, I'll just be clear and concise, because I know there are other people have other questions. Is I just want to know the best way to go about getting an IP valuation done, so I can build that into their pitch deck, basically.
Yeah, so I mean, there's no easy answer to it, I'm afraid. But I mean, just to explain, because there are some jurisdictional differences here, certainly between us and the US. So insofar as we're practicing lawyers, practicing solicitors, and my practices obviously include IP, I tend to get involved in IP transactions. And what that invariably means for your purposes, Sean, is that someone's already identified that there's an IP element, and I'm the lawyer who is drafting the agreements and advising on what that IP element is, or the IP asset, and what we do with it, whether we sell it, license it, etc., invest in it. Insofar as what I think you're saying, if I'm hearing you correctly, we're talking about identifying, the value of what that IP asset is, scrutinizing it, carrying out a degree of due diligence, identifying what the market opportunity might be and what the inherent value comes. So here in the UK, that is the domain of the patent attorney, really. Now, what you'll probably find in the UK is that some patent attorneys, naturally, they come from a technical background. I don't know how familiar with that. Apologies if I'm telling you to suck eggs. But invariably what that means is that the patent attorney, while they're skilled in scrutinising an invention, scrutinising the technical features and making patent applications, they're also from a scientific or technical background, so they understand the underlying technology. And what that means is obviously they're well placed to identify not just whether or not something is capable of having a patent, but also well placed as to giving you a sense and feel as to where it would sit in the marketplace and what its potential value would be. Obviously, what we also find, I mean, we've got in-house patent attorney who works with us, for example, but often, depending on what industry you're in, whether you're in pharmaceuticals, whether you're in software, or advanced engineering, whatever it might be, it can be quite important to not only identify that you need a patent attorney, but you need the right patent attorney with the right technical background to enable you to do that exercise. As you say, invariably there is a cost element to that, but I'm afraid there's not a great deal that can be done about that, because much like Nicholas has talked about, carrying out due diligence on individuals, and in a corporate M&A situation, we carry out a different kind of due diligence. In this context, it's basically due diligence in terms of scrutinising what is being claimed to be the next unicorn product, isn't it? And the final point I'll make is, which is probably expressed in the degree of caution that you see in terms of your engagements, is we do come across clients who have patented products and their patents have proceeded through application to grant, but fundamentally they're not particularly valuable. So I think that's the exercise that we've got to go through. I mean, getting a patent in its own right, you still have to be able to demonstrate it forms part of a product that has great commercial value and an opportunity.
Thank you, David. That's really helpful. I'm sorry, Sean, we need to move on to another question, but it will be great if you can take that offline and you can speak to David and the team after the call. David, we've actually got another question for you, and it's about when is the best time for a business to allocate time and resource for its IP portfolio?
I probably touched on this a bit earlier, and I appreciate it depends on where the business is at in its own development and growth strategy. But clearly, as with most legal advice, and as lawyers, unsurprisingly, we're going to say, as early as possible. And I think, the key reason for that is that, much like I mentioned earlier, quite often we come across situations where clients are trying to resolve situations after the horse has bolted, and quite often the horse hasn't just bolted, the horse has also disappeared across the horizon. And that's not to say that those situations are not fixable as such, but they become more complicated and more difficult to fix with the passage of time. So if we're engaging new individuals to work with us, if we're engaging in new joint ventures, collaborations with parties, absolutely the best time to stop and think about the IP situation as between the interested parties is at the beginning, or certainly very soon at the beginning.
Thank you very much. I think we've got time for one final question, and that is over to Dominic. What do you suggest are priorities for thinking ahead for managing possible disputes?
I think it's working out who are the affected parties, who are the people that matter, and prioritizing is about taking a real risk management perspective on what your relationship is with and going to be and might be over the term of the relationship with the parties that you've identified as those are the most important and those who are least. So reaching a judgment call as early as possible on who are the people and they might be the people who are most surprising, actually. If you think through the term of your agreement, your relationship with them, it can be quite surprising how somebody might become important. And sometimes you need to think about somebody who's involved in the supply context that you need to embrace in that legal relationship, who may not be an automatic player for you, but you might need to bring them on for whatever reason. It might well be either because they are a participant in the supply, or because they act as a surety or some sort of party that's going to be essential to be able to bring in to guarantee the performance of somebody out there who might have a high risk associated with them. So identifying who is going to be important to the performance of the relationship, delivering a successful outcome, valuing those individuals in terms of the risk that they present, but the value that they present, and then invest time in working through how best to ensure that those risks are managed from a legal perspective through the documentation with your lawyers.
That's great. Thank you very much, Dominic. I'm afraid this is all we've got time for today. We've got another question from Sean, which I will let you take further offline. So, as you all know, the slides from today's presentation will be shared with all attendees, as well as the contact details for the team, so you can speak to them following the webinar. I would like to thank Dominic, Nicholas, and David for their time. It's been a very insightful presentation, and I'm sure that people have taken away some really useful ideas and insights. I also want to thank everyone who joined us today. Before you log off, please have a look at our website. Make sure that you check out some of our other webinars that we've got coming up. And we hope to see you again. Have a lovely rest of your day. Thank you very much again.
Thank you very much.